Welcome to our session on protecting business innovations. In our session today, we'll be talking about what can be protected by trademark. Many things can be protected by trademark, including brands. We know that, like Coca-Cola, but also logos, images associated with a brand, like the UST logo for our university, that's trademarked, or phrases like McDonald's, I'm loving it. That's a phrase that's associated with McDonald's, or just do it. These are trademarked. Names also can be trademarked, like Microsoft or McDonald's. These are names, and they can be trademarked. But did you know that you can trademark a color? Now you may say, that sounds weird. I can own a color? Well, not for all products, but for some products or some contexts, you can have a mark on your good that is distinctive and identifies your good. If, for example, you see a woman wearing shoes that have red soles, your reaction may be, if you're familiar with that designer, whoa, those are some expensive shoes, really nice. If you're not familiar with that designer, you may just say, weird looking shoes. But if you do know that designer, that style, that product, those red soles are distinctive to a particular designer and are trademarked. They're protected by law. No one else can bring out red-soled shoes other than that designer, with some minor exceptions approved by the courts where there is a possible exception to that trademark. But by and large, red-soled shoes are protected. You can also protect a sound like the sound your cell phone makes when it turns on, which may relate to a particular manufacturer or to your service provider, or the sound that Windows makes when it turns on. That may be a specific sound that has some meaning to you. You can trademark a design, the way something appears, like a pretzel crisp package or the design of a Ferrari or Mercedes car. So design can be protected. You can protect smells in some cases, not like the smell of a perfume, because that's part of the product itself. So you can't separately trademark the smell of a perfume. But a good example of a smell that was trademarked is Verizon pumps in a specific scent or smell into their retail stores. This is a cell phone company that has a certain smell that they want consumers to experience when you go into their store. And that is a trademark of their brand. Trademark can also be a pattern, like Burberry is a pattern. And so you can get a mark that describes both the word Burberry, but also the pattern itself, and say that's our mark. What can't be protected then? It seems like everything can be protected. But what you cannot protect is anything which is too generic, too descriptive, or too functional. Let's look at generic. Here's a couple of examples. Brands like a Standard brand, Standard Dry Cleaning, General Computers, too generic. That wasn't always the case. At some times in the past, you were able to get some trademarks on names like General Electric, General Motors, General Foods, General Mills. Today, none of those trademarks would work because they're all too generic. They're too general, if you will. But in the past, sometimes you could get trademarks on things which were viewed over time as distinctive enough and carrying a meaning beyond the generic meaning of the words and representing a particular company. Now, most companies try to avoid this by being anything but generic. So Google and Xerox are far from generic. These are great names to get a trademark on because they don't mean anything. They don't have any generic, general meaning to the public. Too descriptive can also make you fail. So if you say Quality Dry Cleaning or Korean Barbecue, the Patent Trademark Office is going to say no. But if it's Sterling Dry Cleaning, that's not descriptive. Sterling is not really anything but a name, and it's more general. Or chop chop barbecue, Korean barbecue, that has some meaning other than just generic or descriptive. Too functional can also get you in trouble, like Vision Center is too much a description of what it does. But Vision Express, well, it's kind of functional, but it's kind of creative and artistic as well. That qualified for a trademark. Fast Computer would not get a trademark. Too functional, too descriptive. But Next Computer, with a funky looking next, that did get a trademark. That is okay. Dell Computer, that is a trademark. That's okay. Dell is not a functional name. Computer's okay if it's combined with something that is not as functional. So what can be protected? Brands, logos, pictures, names, colors, sounds, design, scent, and patterns. All can be protected by trademark. Thank you.